I hope all are good. Today let me start SST chapter number 15, the Judiciary, यानी कि न्यायतंत्र. Judiciary and its importance, मतलब न्यायतंत्र होना क्यों जरूरी है, इसके बारे में हम आज पढ़ेंगे. Okay, Judiciary is the organ of the government which decides the disputes of the individuals according to law, give punishment to those who break the law and award punishment according to law. Okay, बहुत जरूरी है न्यायतंत्र का होना, क्योंकि ये नहीं होगा तो क्या होगा, लोग जैसे चाहे वैसे करेंगे, एक दूसरे को परेशान करेंगे, रहना मुश्किल हो जाएगा. ठीक है. इट ऑल्सो डिसाइड डिस्प्यूट्स दैट अराइज बिटवीन द पीपल एंड द गवर्नमेंट एंड बिटवीन द स्टेट्स एंड द सेंटर ऑफ बिटवीन द स्टेट्स themselves. In any democracy, an independent and impartial judiciary is an absolute necessity. It safeguards not only the rights and liberties of the people but even the democratic setup itself. It is also the guardian of the constitution, which is the supreme law of the land. It enforces the laws in the dispute before it. So interprets the law and gives a new dimension to the existing law. Indian judicial system कैसा है अब यहाँ का जो न्यायतंत्र? India has integrated a judicial system which has a pyramidal structure. At the top is the Supreme Court of India. In the states, the highest court is the High Court. The district and lower courts in the states are under the High Court. There are no separate courts of the union and the states of enforcement of their respective laws. So the Supreme Court of India, the Supreme Court is located in Delhi. It is the highest and the final court of law in India. It is responsible for the protection of the constitution and the rights and the liberties of the people. जो सुप्रीम कोर्ट है वो जो है दिल्ली में है और ये सबसे ऊंची जो है अदालत है. ये जिम्मेदारियों को अच्छे से निभाती है, प्रोटेक्शन और संविधान को जो है कैसे चलाना है, सही तरीके से संविधान के अनुसार कैसे चलना है, इस चीज को तय करती है. ठीक है. कंपोजिशन, द सुप्रीम कोर्ट कंसिस्ट ऑफ द चीफ जस्टिस एंड 33 अदर जजेस. द नंबर ऑफ इट जजेस इज फिक्स्ड बाय द पार्लियामेंट. दिस नंबर मे बी इंक्रीज्ड बाय एन एक्ट ऑफ पार्लियामेंट. सो चीफ जस्टिस एंड अदर जजेस यानी कि चीफ जो मुख्य वो होता है न्यायाधीश और जज. चीफ जस्टिस हेड द सुप्रीम कोर्ट. ही इज अपॉइंटेड बाय द प्रेसिडेंट ऑफ इंडिया. Okay, so other judges are appointed by the president in due consultation with the Chief Justice of India. Okay, so the qualifications essential to become a judge of the Supreme Court are as follows. He should be a citizen of India and he should be an advocate with at least 10 years experience, or a judge of the High Court for 5 years, or a distinguished jurist in the opinion of the president. Terms of office. The judges of the Supreme Court retire at the age of 65 years. If found guilty of misuse of authority, they can be removed from their office by the president. Jurisdiction powers of the Supreme Court. The Supreme Court has 3 kinds of jurisdiction, i.e. power to give judgment, give as under original jurisdiction. In certain cases, the Supreme Court is the sole authority to discharge the function. Such cases originate in the Supreme Court only and include either disputes between 2 or more states. Number 2, the disputes between the union government and one or more state government. Number 3, cases involving the violation of the constitution. Appellate jurisdiction. The Supreme Court is the highest judicial body. It hears appeals against the judgments of the High Court. It can also review its own judgment. It hears appeal in the certain cases which are as follows. When a High Court certifies that a particular case should be tried in the Supreme Court, when a High Court changes the decision of a lower court in a criminal case and awards death punishment. Okay, advisory jurisdiction. The President may refer a matter of constitutional importance to the Supreme Court for its opinion. The President may accept or reject the advice. Functions of the Supreme Court. Number 1, the Supreme Court is the guardian of our constitution. It decides all cases which involve any point of constitutional law. It acts as an interpreter of the constitution. It can declare law made by parliament and the state legislature invalid if found against constitution. The Supreme Court is the guardian of the fundamental rights of the citizen. A citizen of India and can approach it for the protection of his rights. The Supreme Court can declare orders of the government invalid if these are found to violate the rights of the citizens of India. The Supreme Court is the ultimate court of record in India. It maintains a record of its decision and publishes the same. These decisions are quoted by lawyers as precedents while pleading their cases. The Supreme Court supervises and controls the working of the High Courts. Its jurisdiction extends to the whole country. The High Court is the highest court in a state. Okay, some states and union territories share a common High Court, such as Haryana and Punjab and Chandigarh share a common High Court. इन तीनों की एक High Court है ना? In all, there are 24 High Courts in the country. Composition: a High Court consists of a Chief Justice and other judges. The number of judges depends on the size of the state. The Chief Justice is appointed by the President of India in consultation with the Chief Justice of the Supreme Court, and the Governor of the state concerned. Other judges are appointed by the President of India in consultation with the Chief Justice of India. So the Chief Justice of the High Court and the Governor of the state. Qualifications: the qualifications of the Chief Justice and other judges are as follows. He should be a citizen of India. He should have worked as a judge in a court for at least 10 years or as an advocate in the High Court for 10 years, or should be a renowned jurist. Terms: the Chief Justice and other judges hold the office till the age of 62 years. They can be removed from their post earlier by the President of India on receiving a motion passed by the Parliament. Powers and functions. अब इसके powers क्या होते हैं, functions क्या क्या होते हैं? The High Court is the highest court of justice in a state. It enjoys the following power. So number one, original jurisdiction. The original jurisdiction of a High Court includes matters related to fundamental rights and disputes related to state elections. Appellate jurisdiction. The High Court hears appeal in civil and criminal cases decided in the subordinate courts. Supervisory jurisdiction. The High Court controls and supervises the working of the lower courts by examining their courts. It maintains a record of all its decisions and proceedings which are quoted by the lawyers of the subordinate courts. What is subordinate courts? The subordinate courts include all the courts at the district level and below. So they are different courts in a district to try civil and criminal cases. Okay, so civil cases are tried in the court of district judge. These court and can hear appeals against lower courts. Smaller civil cases are tried by municip and sub-judge in the lower courts. Criminal cases are tried in the court of the session judge. The district judge act as the district and session judge. Criminal cases are also heard by magistrate in the lower court. The court of the session judge hears appeals against the decision of the lower courts. Okay, so the judges of the subordinate court other than the district judges are appointed by the governor from the state judicial services. They are recommended by the state public service commission. Their salary and allowances are decided by the respective state government. लोक अदालत. कुछ ऐसी ये लोक अदालत वो होती है, कई बार हाई कोर्ट सुप्रीम कोर्ट नहीं जाना पड़ता, जो लोक अदालतें बैठती हैं उनमें सॉल्यूशन हो जाता है. द लीगल प्रोसेस इन आवर कंट्री हैज बिकम लेंथी एंड एक्सपेंसिव, है ना. हमारा जो लीगल एक्शन है जो लिया जाता है वो बहुत ही क्या है, लेंथी है और बहुत ही एक्सपेंसिव यानी कि महंगा है. वकीलों को बहुत पैसे देने पड़ते हैं. ठीक है. इन ऑर्डर टू सेव बोथ टाइम एंड मनी, समय और पैसे दोनों को बचाने के लिए क्या लगती है जगह जगह लोक अदालत. पीपल्स कोर्ट हैव बीन एस्टैब्लिश्ड. दीज आर वॉलंटरी एजेंसीज. दिस सिस्टम हैज सिंप्लीफाइड द लीगल प्रोसीड्यूर. द लोक अदालत आर प्रिसाइडेड ओवर बाय रिटायर्ड जजेस. जो रिटायर्ड जज होते हैं ना उनके अंडर लगती है. ठीक है. द डिस्प्यूटिंग पार्टीज प्रेजेंट देयर केस एंड द मैटर इज सेटल्ड विदाउट अ प्लीडर. The judgment of the Lok Adalat is deemed to be a decree of a civil court. The Lok Adalat have proved very effective in providing speedy and cheap justice to the common people. The first Lok Adalat held in Delhi in 1985 decided 150 cases in a single day. एक दिन में 150 केस जो है सॉल्व किए. Thus these Lok Adalats have lightened the burden of other courts as well. तो क्या होता है जब यहाँ पे मसले हल हो जाते हैं तो जो अदालतें हैं, जो हाई कोर्ट सुप्रीम कोर्ट है, वहां नहीं पहुंच पाती बहुत सी चीजें, तो वहीं पे सॉर्ट आउट हो जाती है. द लोक अदालत आर लाइक पंचायत एंड दीज मेक एफर्ट्स फॉर म्यूचुअल एग्रीमेंट एंड कॉम्प्रोमाइज. The following types of cases are more suitable to be taken by them. Cases of compensation like those arising out of accidents, family disputes like those of separation, divorce, custody of children, guardianship, deaths, family, partitions, property given at the time of marriage, maintenance, etc. Landlord tenant cases, enhancement of rent, ejectment, subletting, non-payment of rent, maintenance of rented premises. Main types of judicial cases. Judicial cases may be broadly classified into two types, civil cases and criminal cases. There are some distinctions between the civil cases and criminal cases which may be stated as below. Civil cases are concerned about private rights, okay, whereas criminal cases are those wrong committed against the community as a whole. Civil cases include trespass, negligence, breach of contract, matrimonial cases, etc. While cases of serious nature such as murder, criminal conspiracy, cheating, food, adulteration, etc. are categorized as criminal cases. So, the remedies and procedure for civil and criminal cases are different. The remedies for civil wrongs include claim for compensation or specific performance or injunctions and such other remedies. The remedies in criminal cases, on the other hand, include awarding punishment to the guilty and to compensate the victim for his or her grievance under specific circumstances. Many civil cases are settled out of court by the involved parties, but such is not the case with the criminal cases because they are the state it also involved. Difference between the role of the court and the police. The court and the police together play a vital role in the administration of justice, but their role is quite different from each other. Okay, so role of the court, as discussed earlier, the court play a vital role in the administration of justice. They try to provide justice to the people and punish the guilty. From the lowest district court to the highest Supreme Court level, these courts try to verify the fact closely and hear the arguments of both parties. So, appellant and respondent supported by witness. Okay, so after the close examination of the whole case, they give their judgment. If either of the parties is not satisfied with the judgment, it can go in appeal to the higher court. है ना, अगर वहाँ पे हम satisfy नहीं हो रहे. Besides deciding the case of the individual, the court also play a vital role in the administrative setup of the country. In the following ways, they act as the custodian of the constitution, they protect the fundamental rights of the citizens, they keep a check on the power of the legislature and executive, so they can declare certain law as ultra-virus and unconstitutional. They decide the center-state disputes or disputes arising between two or more states. They advise the president to the governors on matters of law. Role of the public prosecutor. Public prosecutors are gazetted officers appointed by the state to help in the prosecution of offenders in order to keep the society free from crime. Their offices are situated in the court building. Okay, to present criminal system is based on the principle that any crime committed by an individual as a crime against society he lives in. Therefore, the prosecution and punishment of the crime is the responsibility of the state. Such prosecution on behalf of the state is undertaken by a public prosecutor. The public prosecutor is required to play an important, impartial and neutral role and help in the prosecution of all those charged sheeted by the police. It is quite a difficult task because he faces tremendous pressure from the government as well as from powerful and influential people. So the public prosecutor is expected to place all the evidences in his possessions before the court during the investigating stage until the filling of the charge sheet. The investigating agency for the or the police is in control of the proceeding after the charge sheet has been filled in the court. The public prosecutor takes over both play a complementary role in the judicial system. Role of the police. The police is an important pillar of administration. So during the colonial rule, the main functions of the police comprises of enforcement of law, maintenance of order, investigation of crime, okay, detention of criminals, arrest, collection of evidence, and getting conviction. So these functions of the police are called traditional functions. Okay, so with the dawn of independence and democracy in India, the concept of police functions underwent changes. Now the police supposed to do many welfare functions which include service to weaker sections, women, children, handicapped, etc. as per the rules and process of law. So, for checking the efficiency of the police, some scholars have suggested various norms, some of which are as follows. Feeling of security in the society, willingness of the people to cooperate and participate in the prevention of crime, maintenance of law and order with people's cooperation, feeling of service in police personnel towards women, children and handicapped. Service by the police to the people during natural calamities. Registering the FIR, prompt visit by the police on the site of incident and proper investigation. It is desirable that the state initiates efforts to update the Police Act to uphold democratic values and cultures and equip the organization with the latest gadgets. First information report means FIR. The first information report is the information that a police officer receives about the commission of a crime. The following are some of the salient features of the law regarding the first information report. An FIR must be lodged in writing, duly signed, and the copy must be handed over to the informant. It is generally a complaint lodged with the police by the victim of the cognizable offence. It is not necessary that only the victim file an FIR. Anyone who knows about the commission of a cognizable offence can file an FIR. A police officer who comes to know about a cognizable offence can file an FIR himself. In time of incident, a detailed description of the incident is also very necessary. An FIR can be filed at any police station in the country. It is the duty of the police officer to send it to the police station which has the jurisdiction over the matter. When the information about a cognizable offence is given orally, the police must write it down. Every complaint has a right to ask for a copy of the FIR free of cost. There is no fixed time for filling an FIR, but it is to be filed at the earliest soon after the incident. Denial to lodge a complaint. The denial to lodge a complaint is illegal on the part of the police office because an FIR is a very important document for starting the process of criminal justice. After the FIR is registered, the police take up the investigation of the case. If a police officer in charge of the police station refuses to register the FIR, the complaint can resort to the following methods. The report may be sent in writing to the superintendent of police specifying all the details of the incident concerning the refusal of the police officer in re-registering the case. The superintendent of police or even higher officials, even the deputy inspector general of police may be contacted and informed about the complaint. Complaint before the court may also be filed. If the police does not register the case and does not take any action or does it in a biased manner, the complaint may be made to the State Human Rights Commission. Supreme Court's directive on not accepting FIR by the police. On February 22, 2006, the Supreme Court held that police cannot refuse to register an FIR or form a complaint simply on the basis of doubts of credibility of a received complaints. The bench of judges H.K. Seema and A.R. Lakshmanan quoted an earlier decision and said it is mandatory for a police officer to register a complaint of a cognizable offence and that the police could not prejudge the issue or the case. Police को कोई right नहीं है उस चीज को judge करने का. At the stage of registration of a case, a police officer cannot embark upon an inquiry whether the information is reliable or not. So the police must and have to register the complaint. वो केवल complaint register कर सकते हैं, बाकी उन्हें उस चीज के ऊपर जो है कोई न्याय देने का या कोई फैसला सुनाने का उन्हें राइट नहीं है. अगर वो वहाँ पे छोटी मोटी चीजें सुलझा सकते हैं, इट्स ओके, बट वो चीजें सीधा कोर्ट में जाती है. ओके, so the all topics are covered in this chapter here. I hope you all are very well understand this chapter. We will meet to the next class. Thank you everyone.